I call Dennis O'Rourke.
Mr Speaker, before I heard David Cunliffe, I thought this was a non-controversial and non-political bill. and actually, I think that it is. And I expect it will be supported by all parties, and it will certainly be supported by New Zealand First. In fact, it's a pleasure to see such an important and comprehensive piece of legislation begin the enactment process. And I want to begin by acknowledging the long years of hard work by the Law Commission and others on this bill, and in particular the late George Tanner QC of the Commission and the late Warren Moyes of the Office of the Registrar General of Land. I think this bill is a fitting tribute to their effort, their dedication and their professionalism. Mr Speaker, New Zealand has long been blessed with an efficient, reliable and effective land registration system, and it's still based on the Torrens system of title by registration, which grants the high indefeasibility of state-registered proprietorship of land and effectively guarantees title upon registration of a transfer or a transmission. And the system was named after Sir Robert Richard Torrens, the third Premier of South Australia, and became the method adopted within the English law countries almost 100 years ago now. It was progressively replaced the deed system, thus providing certainty and simplicity to land transactions by doing away with the need for proving a chain of title by searching through a whole chain of deeds and other documents. Mr Speaker, before finishing my law degree as a very young law clerk, just a few years ago now, my job was to search titles, fill out things that were called search notes in pencil by searching through huge, dusty books of titles, which was a horrible job. But if that was bad enough, where there was no registered title and there was still land that wasn't within the system, you did have to search through the registered deeds that were available, and that was very time-consuming, not very rewarding, and very archaic. However, it had to be done, and the system has improved and improved and improved over many years, but even the current system has had its challenges, and I remember appearing in the High Court in a number of cases concerning unclaimed land and because of the informal transfers of land. And I remember on the West Coast one particular case where a certificate of title was handed to me and it had written on it in pencil a number of memorials like, last Saturday I sold this land to Joe Bloggs, dated so-and-so Bill Brown. And there were a whole list of memorials like that. Nobody, it had never been registered or nothing formal ever done, but we found a way of getting around all that and rectifying the title with the cooperation of some very practically minded judges, and I recall in particular the late Justice Roper, who I thought had a particularly good and practical system of dealing with those sorts of situations. However, the system basically worked very well, and by the time I surrendered my practicing certificate and gave up practice in 2002, the system had been computerised and was online. So over all those years, it really travelled a long way. And Mr Speaker, the Torrens system itself works on three fundamental principles. One's called the mirror principle, which reflects accurately and completely the current facts about each title by way of a certified memorial on the face of the title document itself, whether it be a transfer, transmission, mortgage or a discharge of a mortgage, a lease or an easement or a registrable covenant or whatever. And the second was the curtain principle. There was no need to go behind the certificate of title. Everything you needed to know and everything affecting that title was recorded on the face of it. And then thirdly and lastly, the indemnity principle, providing state compensation for loss caused by private fraud or by errors made by the registrar, which caused a loss by the person who was claiming the title to the land. So I think that that stood the system well over many years, And all of it was in the 1952 Land Transfer Act as amended in 1963 and later in 2002. And by that time, of course, it had moved away from a paper system in favour of the current electronic one. But the old legislation isn't well structured for that electronic system, and so this bill is welcome because it modernises the law and brings it up to date with those systems as we now see them. And it has great advantages for everybody. Lawyers and conveyancers can search titles and process transactions from their own offices, therefore costs are lower, survey information is better integrated and security is improved. Now, Mr. Speaker, the two main changes that I see incorporated in this bill are, first of all, judicial discretion to alter a title in cases of manifest injustice. That's always been needed. It's really good to see that finally arriving. And another one which has been long coming and very welcome is the provision to avoid mortgage fraud by requiring a mortgagee or their lawyer or agent to verify the identity of the mortgagor, thus ensuring that the mortgagor does in fact have the legal authority to mortgage the land. That's always been a serious flaw in the system, and it's good to see that hole being plugged. Mr. Speaker, state guarantee is preserved in the bill and compensation is still payable. And where loss, for example, occurs from a guaranteed search, compensation is, as has always been the case, payable, but now for a shorter period, and that just reflects the speedier transactioning processing now available and is quite appropriate. And also land value will now be at the date of the claim, as at the date of the claim rather than as at the date of the loss, because that was always not easy to fix, and it also allows for consideration of improvements post-loss. So that's another welcome change. And another one is to reduce compensation where there is some fault attributable to the claimant's lawyer or conveyancer. That's very appropriate. Now, Mr. Speaker, there are many other changes to the bill, far too numerous to mention here, but I'm glad to see that there is now a definition of fraud, better protection of legal administrators from personal liability, better ways of recording easements in gross, and better control over the way statutory land charges are administered, because they were always a bit of a mess. Just to name a few. So the bill really takes some important leaps forward, I believe, and is a very welcome piece of legislation, as I've said. Another thing that it does is to make the land register subject to the Privacy Act and its principles, thus permitting personal information to be protected in appropriate circumstances. I'm glad to see that as well. And of course, since last year, tax statements have been required, and that's incorporated in the new legislation and is a prerequisite to registration of a transaction. Now, Mr. Speaker, that clears the way for something that New Zealand First has wanted for a long time, and that's control over who can actually own land. Very important to New Zealand First, because we want to put a stop to the sale of productive land and existing houses to overseas citizens not resident in New Zealand. And I'm glad to see that the Labor Party has caught up with that policy and adopted it as well. And we're glad to provide a policy-making service to the Labor Party and other parties in that way. So it's good to see that happen, Mr. Speaker. But overall, Mr. Speaker, this is a welcome piece of legislation, and I look forward to studying it in a lot more detail as it progresses through the House. New Zealand First will be voting in favour.